So we'll just dive into it. The voters of Washington were not confused. They have voted 3 times for an initiative that anyone can understand. It was about lowering the cost of actually having a vehicle in the state of Washington. Everything in the initiative did that. Everything about the initiative was clear. If there was any ambiguity, the opposition had $5 million to convince voters to vote no on the initiative. Yet the voters had voted for this thing so many times previously that they had an easy time going, when are you going to give me back my $30 tabs? So the initiative passes overwhelmingly. Clearly, when I ended up putting this initiative together, I learned from the previous experiences. So the first time we did the initiative in 1999, the initiative said we're going to lower our car tabs, and we want to make sure that state and local governments don't retaliate against us. And so the initiative said we're going to require voter approval for every tax and fee increase at the state and the local level, whether it's related to vehicles or not. We said that this is all related to one another because it's all about limiting taxation. The lower court judge ended up disagreeing with us and said, no, that's 2 subjects. So when we did the initiative, and after the initiative was struck down, Governor Gary Locke, a Democrat, with the legislature overwhelmingly controlled by the Democrats, ended up calling a special session. He called it the day of the court's ruling. And he specifically said it's important for the legislature to act immediately on this to remove any uncertainty in the minds of the citizens of the state of Washington, to make it very clear that we will carry out Initiative 695. He said at his news conference, the governor said voters were clear that they hated the high car tab fees. So it's very clear that even 21 years ago, the voters knew what the $30 tabs initiative did. They clearly knew again about the new initiative because they had voted for this same initiative so many times previously. And so it is truly maddening to me for the court to say that the voters were confused by an initiative that is so straightforward and so understandable. It's really infuriating. I am reminded the fact, of course, that a King County judge, Judge Ferguson, somebody I was very critical of because he was a Jay Inslee appointed judge, he came to the conclusion that all the initiative provisions all had to do with the topic of lowering our vehicle tabs, that it was all germane, it has rational unity. So we have 9 justices on the Supreme Court that are to the left of a Jay Inslee appointed judge in King County. So the voters of this state are right to be angry, right to be outraged. The points I would make is, 1, I ain't renewing my car tabs, and I encourage everybody to do the same. Mine expired back in October of 2019, and there's no way they're getting a penny out of me until these guys actually implement the will of the people and get our $30 tabs. So that's what people can do now. For those people that wonder, well, what happens if you get pulled over? I've been pulled over twice over the last year, and both times I gave the officer the same presentation. I said, the voters voted for this initiative. I didn't forget to pay. I just think that I shouldn't have to pay more than what the voters voted for. Please, officer, use your discretion and issue me a warning today. Both cases, I got a warning. Same thing happened with Dave McMullen at Pierce County. Same spiel. Officer gave him a warning. My son has been pulled over twice, expired tabs. Both times he gave the same thing, saying, please use your discretion, officer. I think even law enforcement understands the injustice that's going on here, and I think they understand where they're coming from. But when this ruling came down, I just got angry. I just got furious. The voters have said over and over again what they want, and I thought to myself, well, what would Gary Locke be doing right now? Gary Locke would be saying, you know what, I'm going to do what I did 21 years ago. I'm going to call a special session of the legislature because it's clear what the voters wanted. Here we're dealing with Jay Inslee. And Jay Inslee is no Gary Locke. Not responsive, not respectful of the voters. And so I think it's important for all of us to push for a special session of the legislature. There's no reason why they can't do exactly what they did 21 years ago. But in this case, unlike Gary Locke, who was only dealing with an initiative that had passed 1 time, here you're dealing with an initiative that had passed 3 different times. The voters clearly want to get rid of this dishonest vehicle valuation schedule that is taxing a $10,000 car like it's worth $25,000. So dishonest, so unfair, and the whole reason you have the initiative process is we shouldn't have to vote people out of office to get a policy we want. Here we've got a policy the voters clearly want. You shouldn't have to vote for somebody else to get it. You ought to have elected officials willing to do that. And I know Gary Locke was not a fan of 695. He campaigned against it, yet he accepted the will of the people within seconds of hearing about the court's ruling, because he knew that there was no confusion. He knew the voters knew what they wanted, and he set about implementing it. We had Democrats controlling the House and the Senate back then, and yet it passed 83-13 in the House, 39-9 in the Senate, and Governor Gary Locke signed that into law. Simply no reason they can't do that as well. With that segue, I'll turn it over to Jim. But people are right to be angry, right to be outraged. Your vote should count, but it didn't count because 9 justices on the Supreme Court said the voters were confused, and I know that they weren't. And if we have to do a 4th initiative, we can, but is it really necessary? I mean, the whole reason you do an initiative is to show what the voters want. Clearly the voters want this, and they just need to have elected officials that are willing to listen. Gary Locke was willing to listen 21 years ago. Let's find out about our governor. So I'll turn it over to Jim.
Thanks.
And then we'll do Q&A.
Today's opinion from the state Supreme Court is an outrage, it's a miscarriage of justice, and it's an affront to the people of Washington who've spoken clearly on this matter of car tabs. The state Supreme Court, the 9 justices, should be ashamed of this opinion. They fail in their most essential duty in issuing this opinion, which is to offer clarity and consistency in the law in the state of Washington. The logic in today's opinion is the opposite of the logic that the same 9 judges exhibited just recently when they upheld I-1639, the gun control initiative. So rather than offering clarity in the law to the people of Washington, they are offering chaos, confusion, and uncertainty. And that is an egregious failure on the part of the state Supreme Court. The state's Attorney General also is shamefaced today, or should be. He failed, according to the court, to write a clear and coherent title to this initiative, leaving the people confused, according to the court, though I, of course, think the people were not confused. And then the state Attorney General failed again by bumbling the case for his title in front of the 9 judges. So it is a bad day for Bob Ferguson. He has failed the people of Washington. Now, I call on Governor Jay Inslee to immediately convene a special session of the state legislature following the history and the precedent set by his predecessor, Gary Locke, in which the legislature can recognize and respect the will of the people of Washington and pass this initiative into law through the legislative process. It is incumbent on the governor to recognize the will of the people. Otherwise, we face a constitutional crisis in this state, in which one branch of our state government is overreaching its regular role and setting into imbalance and chaos the natural balance of power that should exist among the 3 branches of government: the judicial, the legislative, and the executive. Now, given our system, right now, the executive, the governor, is in the best position to right this outrage. And if the governor fails to do that immediately, then the governor is joining the judges in failing the people of Washington. And then it's on us, the legislature, to recognize the will of the people. And in that case, we need to call ourselves into special session. That requires a supermajority of the legislature, necessarily bipartisan, to convene our own special session in which we can recognize the will of the people. This outrageous disregard for the clearly stated will of the voters of Washington has to end. Our Constitution says in Article 1, Section 1, right at the start, that all political power is inherent in the people. Our judges, our governor, our state attorney general, they need to recognize that constitutional, foundational statement. Until they do, we are in a constitutional crisis in the state of Washington. Thank you.
I just want you to stay up here and we'll just
Sure.
do some Q&A and wherever you guys want to go. Essex, you were there back then, so how about start with you? I think Jim was too. Yeah, please.
Sure.
You know, it's 3 times Mr. Eyman has gotten voters' hopes up, written an initiative, 3 times they've passed it, 3 times the courts have rejected it.
Not true. Not true on the second one, but go ahead.
All right, even if it's only twice. In this case, should voters be outraged at Mr. Eyman for, with all his experience, writing an initiative that still gets overturned?
I think the more relevant comparison is to the court's recent decision on 1639. By the logic of that decision, this initiative should have been upheld. So the outrage should be at the judges on the state Supreme Court.
But Tim Eyman just can't seem to get it right.
That's your opinion, Essex, and I don't have an opinion on that. I'm more concerned about the state Supreme Court, which is in a position, and not just in a position, it's the duty of the court to provide clarity and consistency in the law. That's what they're there for, and they're failing that duty.
Oh, yeah. 19 things.
Right. The court accepted multiple elements, multiple topics, as it were, in 1639, yet used the argument that this initiative includes really 2 elements, but multiple elements here, as one of the reasons to reject. That's an inconsistent position for the judges to take. And it leads to confusion and chaos and uncertainty. And frankly, in the long run, it leads to less credibility for the state Supreme Court. And that's something we can't afford. If those 9 individuals want to push partisan policy, they ought to run for the legislature and join me over in that building. In this building, they're supposed to provide clarity and consistency in the law.
I'm thinking back on 1639,
Yeah.
did the state Supreme Court rule on that after it was passed? I remember the case before, it was a week before voters. The federal judges upheld 1639 as
Right.
constitutional.
They allowed it to go forward, but on the same logic as that.
Well, the logic at the time was that they don't weigh in on initiatives beforehand.
No, okay, that's fine, but their logic is still not consistent. By the logic of this decision, that decision should have been overturned.
I want to go ahead and do Essex thing because it's an important point. I've dedicated my life for the last 22 years to putting together initiatives that put limits on government's power. And clearly, I've learned a lot over the years about what works and what doesn't. And I think you can see that the first initiative that I did on lowering car tabs included something that I think voters were very much in favor of, voter approval of every tax and fee increase. But the second time I did the $30 tabs initiative, I looked at the ruling and said, okay, they said there was nothing wrong with lowering the cost of vehicles, vehicle costs as far as government costs are concerned. Let me make sure that I draft the new initiative so that it just focuses on that. When that initiative went forward, the opponents ended up making the same arguments. The voters ended up voting for it again, and the opponents challenged it on the single subject rule, and the Supreme Court upheld it on the single subject rule. 776 said we're going to get rid of state taxes, state fees, get rid of this vehicle valuation system, and address the bonding issue. They upheld it on the single subject rule. I was following the roadmap that the Supreme Court ruled that's single subject. So I cannot follow the rules when the rules change. I can follow the rules that they lay out, but if they come up with new rules, it makes it a lot more difficult. To show how committed I was to this initiative, I sold off our retirement fund and loaned $500,000 to the initiative to kickstart it on day one back in March of 2018. I wouldn't have put my own money into it unless I felt confident that I had followed all the rules, that the voters were on our side, that it would be upheld. But I can't follow rules that change. Clearly, the voters know what they're voting for every single time. You have an entire campaign over it. This idea that getting rid of the bonds is somehow a separate subject. You couldn't get rid of the tax without getting rid of the bonds. The whole reason why Judge Ferguson down in King County upheld the initiative on the single subject is he agreed that that all makes sense. You can't get rid of the tax unless you get rid of the bonds. And so therefore the initiative clearly followed the rules that the Supreme Court laid out in 2003, but the Supreme Court in 2019 clearly disagrees with the court from 2003. So, thank you. The initiative passed in 2019, but you're right. So Judge Ferguson, who I was very critical of, being a King County judge, where one of the plaintiffs was his boss, who was appointed by Jay Inslee, could find that the entire initiative all related to the idea of trying to lower vehicle tabs. But 9 justices on the Supreme Court are to the left of a judge appointed by Jay Inslee. It is infuriating. They could have found a way to be able to uphold it. They could have found a way to be able to do it, but because the initiative limits government's power, it's held to one standard. Jim highlighted the beginning of our Constitution. It says all power is inherent in the people. We need to modify that. All power is inherent in liberal people. If it is all power is not inherent in conservative people. If you vote for a conservative initiative, you're held to one standard. If you pass a liberal initiative, you're held to a different standard. That doesn't mean that we stop. It just means that it's harder for us. We have to earn it. I would like to think 3 votes shows you earned it. The fact you're willing to put your own money into your own idea shows that I was clearly committed to this idea and felt confident that it would make it through the gauntlet, even with this liberal Supreme Court. Doesn't mean we can't do it again. I'm more than willing to do it again. I'm out of retirement funds, however, so I'm more than willing to do it, but I shouldn't have to. The voters shouldn't have to. They voted 3 times to get rid of this dishonest, artificially inflated vehicle valuation schedule. At a minimum, can't they have a special session that gets rid of that valuation schedule and does it based on market value? Can't they at least do that? What's that again?
You didn't get your retirement money back?
No, I did not. It was a loan. So I've gotten back, I think, 12,000 of it. So I was committed. I am committed. I fought for 22 years for this policy. I'll fight for another 22 years if that's what it takes. But it shouldn't take another initiative. It should take responsive leaders like Jim Walsh, and it should take even a liberal governor like Jay Inslee to recognize that a liberal governor, Gary Locke, can disagree with the idea, but agree that the voters knew what they were doing.
Uphold the will of the people. There's to Tim's point about only some of the people have political power inherent in them, there's a bizarre passage in today's decision in which the court points out that although a strong majority of the people of the state passed 976, the people in certain parts of the state didn't pass it. It singles out those parts of the state, specifically the geographic area included in the Sound Transit region, and I think it was Island County and King County, as having not, in those small areas, having not supported 976, and apparently gives some kind of special deference to those areas. That's an egregiously faulty piece of logic there.
Excuse me, I don't have the...
Just real quick, Drew, you had a question, then I'll come back to Jim.
We'll come back.
Okay, please, yeah, go ahead.
I don't have an opinion memorized, but wasn't the court talking about the King County vote in relation to log rolling, where they said, you know, you added Puget Sound, which is where Sound Transit has approved something, you're giving all of the voters in the state the opportunity to get rid of them.
I can.
It's the same faulty logic, though. Yes, it is.
It's not. That particular argument was made in 2002 against the previous initiative. You can't have a statewide initiative that affects local governments. And the Supreme Court said, absolutely you can, because the legislature creates taxes, the ability to raise taxes. The legislature or the people can rescind that authority anytime they want to. But that was a court in 2003. Clearly the rules might be different today with this Supreme Court, but back then it was a recognition that local governments don't just have taxing authority. They only have the authority that the state allows them to have. And the state at any time can withdraw that authority.
And that's the problem, is this shifting ground. This shifting ground is the problem. We don't know how to proceed with public policy when we can't predict any continuity or consistency from the justices.
But Joe was going to address the, why would you allow everybody to do it? The Sound Transit District was created to not allow the initiative of referendum power within that district, leaving only the legislature and the people to do something when something is wrong. Here we have a valuation system that is clearly dishonest, artificially inflated, unfair, and the people that voted for Sound Transit 3 were told their car tabs will only go up about 80 bucks. But when they're getting a bill for $300, $500, $800, they're furious, they're outraged. They reach out to their elected officials. They say, this is outrageous, do something about this. They had 2 legislative sessions to do something about it, and they did absolutely nothing. If they had addressed the issue, as Jerry Cornfield brought up during a debate, why didn't you do an initiative that just addressed the Puget Sound region? Because there is no initiative process in the Puget Sound region. The only option you have is elected officials or the people. And we exercised our right to put on the ballot something that 66% of Pierce County voters voted for, that 57% of Snohomish County voters voted for, that 53% of non-Seattle King County voters voted for. It was only Seattle that made it even look close. And the reality is, it shouldn't matter where you live. Your vote should count the same. It doesn't matter if you're a Seattle voter or a Pend Oreille County voter, your vote should count the same. Not today. If you were from Seattle, your vote was validated, but if you were in the majority, it went in the opposite direction. I want to get back to Drew, and then we'll come back to you.
We just asked the governor about his reaction and whether or not the fact that voters made this call, should they be honored by him taking action, legislators taking action to lower the car tab fees. He said it's obvious they're frustrated. He said he's open to reform, but he didn't want it to impact the transportation project. Any thought on whether or not you expect anything to happen in the legislature as a result of this?
Well, I am going to press as hard and loud as I can for something to happen. The will of the people. The reason we exist in the legislature is to give a voice to the will of the people. So I think it's incumbent on us to make something happen. Now, all I can do is ask the people of this state to contact the governor and demand that he call a special session of the legislature to rectify this injustice. If he chooses not to do that, we do have, in our discretion, the ability to convene our own special session. That requires a supermajority of my colleagues and necessarily bipartisan supermajority. So we need to reach across the aisle. We need to put R&D aside, and we need to represent the voice of the people of Washington. And we need to do that immediately. We need to do that as soon as possible.
I
have hope that it will happen, Drew.
Yeah, exactly. Jim, Tim, yeah, it's, if the governor was serious, he would call a special session today. He wouldn't just say, I'm open to it. He would actually call it today, because that's exactly what Gary Locke did. Gary Locke didn't wait around for reporters to ask him. He called us a news conference that day, the day the ruling came down, and said, I'm calling a special session of legislature immediately, and I'm implementing what the will of the people was. It's important for the this is the exact quote. It's important for the legislature to act immediately on this to remove any uncertainty in the minds of the citizens of the state of Washington, to make it very clearly we will carry out Initiative 695. He was proactive. He was a leader. He accepted the fact that even though he was against the initiative, he recognized that the voters wanted it. Jay Inslee, by the saying, I'm open to it, but not calling a special session, shows that he's not going to do anything. He literally had multiple years to do something about it. Now he's had 3 votes of the people, a dishonest valuation system. People are furious, and he's basically saying, what are you going to do about it? And it's frustrating, and it's maddening, but it really is incumbent on him. The idea of getting 2/3 of the vote for them to call a special session, it has to be Inslee, or else it's not going to happen.
I'm a little more optimistic than that. I believe
that
the voice of the people wills out. The voice of the people ultimately decides.
I agree with that.
And if the governor doesn't recognize the voice of the people, and if a legislative supermajority doesn't recognize the voice of the people on this matter, the people have the chance to exercise their voice again on November 3rd.
Oh, that's true.
And so, you know, the voice of the people, the foundational, constitutional vesting of political power in the people of the state, it's a force of nature. It won't be constrained. It's like trying to dam a river. This river is strong. And if current elected officials don't recognize the righteous voice of the people, then the people will find a way. And they'll either find a way in a special legislative session, or they'll find a way this November, or they'll find a way at some future point. But they will find a way. This is a crisis. This is not the way that government and public policy is supposed to work in the state of Washington. We're being hijacked by a minority, and they're acting as if they're a majority. The majority of the people spoke in I-976. That needs to be honored. And it is incoherent, inconsistent, hypocritical of the same people who defend the will of the people in I-1639 to now ignore it in I-976. You can't have it both ways.
It is worth noting just the percentages. I mean, it is mind-blowing. The opposition had $5 million and we had nothing. It passes overwhelmingly statewide, 53-47, but that is even a misleading number because the Seattle vote was so overwhelmingly against it that 53-47 got tighter. It was 59% outside of King County. It was well over 70% in many counties. I am just dumbfounded. You have this overwhelmingly strong support for getting rid of this vehicle valuation system, which is so dishonest and so unfair, and yet the voters have rejected it 3 different times, and yet it's still in effect. I am a glasses half full guy, so it is worth noting that when I first started this fight back in 1999, it used to be 2.5% of the dishonest, artificially inflated value of a vehicle. Now, in 36 out of 39 counties, there is no vehicle valuation schedule being used at all. It's only a couple of late fees. They still suck. I don't like them. The voters have rejected them, but there's none of that. Within the Puget Sound region, as infuriating as it is that your car tabs have skyrocketed, instead of 2.5%, the way it used to be, it's now 1.1%. It is still a dishonest valuation system being multiplied times a number that's lower than it used to be, but people have saved billions of dollars by doing these initiatives, by pressuring the legislature, by voting for these measures, but I can't stop this fight until it's 30, because the voters have said this is what they want. That's the reason why we did it in the first place. We picked $30 because we wanted to be comparable to Idaho and Oregon, and we just wanted to have a reasonable fee just to license your vehicle. They're already raping you with the sales tax, raping you with the gas tax. They're already getting more than their fair share. They shouldn't triple dip you and triple tax you with this outrageous car tab tax. When I did it the first time, it was a new idea, new concept. Voters voted for it. We've had 20 years to get used to it, and it's 20 years of voters seeing it with it being lower and with it being higher, and 3 times the voters have said we want it to be lower. So. I would do a 4th one in a heartbeat. Easy to do. I can absolutely do it. There's no reason we can't do it. But you do initiatives to prove the voters are on your side. I've already proven that 3 times. The voters already have said this valuation schedule is unfair, dishonest, inappropriate. There's clearly a way to be able to do it. And whenever the legislature does something, it's always legal.
I think the weight is on the legislature and the executive now to act. It's not appropriate at this point in time to be talking about a 4th pass at the initiative. It is more appropriate to say the weight's on us, the elected officials, the legislature, and the governor, and even the state attorney general, if he can find which way is up on this issue. It's on us to act, and we must.
This issue of multiple subjects is obviously. Why couldn't this initiative just have said $30 car tax, period?
That's exactly what we did in the second initiative we did, Initiative 776. And the Supreme Court said as long as these bonds are outstanding in Sound Transit's district, we're not able to get rid of the tax. So learning from that ruling said, okay, we have to find a way to be able to retire these bonds. The bonds admitted to by Sound Transit's lawyer, they can be retired early. So the initiative required that they retire them early if they can. You can't get rid of the tax unless you address the bonding issue. And the reality is if you don't address the bonding issue, then you run into a bond impairment. So there is a way to do it. It can be done. It does seem absurd to me when I heard this one. You would have to do a separate initiative to retire the bonds. I'm trying to visualize how this would work. Vote for this initiative over here, but make sure you got to pass this one over here, and I would constantly be referencing this one to this one. Clearly, they're related to one another. They're germane. They have rational unity, but Judge Ferguson said that all makes sense. And just to illustrate it, I can't help but be frustrated by this, is that the initiative said to effectuate the policies, purposes, and intent of this act to get rid of the motor vehicle excise tax, and authority shall retire its bonds. It was intended to be able to, so that we can get rid of the tax. The tax was repealed, the 0.3% in Sound Transit was repealed by 776, and they said as soon as those bonds go away, that tax will go away. The only way you can get rid of the tax is to get rid of the bonds. So I have dedicated my life to doing initiatives. I take it very seriously. I put in my own money to show how committed I was to this idea. I've done it for 22 years, this basic policy goal. And people have said, what's the big deal about $30 tabs? It's not the dollar amount. It's the lack of respect you have from elected officials when you can have an initiative that is so straightforward and so understandable to everybody, and yet they're told by politicians that the voters just didn't know what they were voting on. You just can't say that the third time.
And this is dangerous. That attitude undermines the credibility of our institutions. If people begin to think that it's a sham, it's a game, it's kangaroo court, their vote never counts, they stop voting. And that's immoral. That's terrible. That leads to bad government, that leads to bad policy, that leads to tyranny. We have to protect the people's trust in our institutions in this state. We can't hear from people, I'm not going to vote because my vote doesn't count, because they'll just ignore it and they'll find an excuse anyway to throw it out. This is a real risk we face. We have to respect and honor the will of the people. It's fundamental.
And the initiative process does exist for people across the political spectrum. It should be available to liberal activists. It ought to be also available to conservative activists. If the voters vote for it, whether it's a liberal initiative or a conservative initiative, they ought to have that right respected. I'd like to think that you would have extra respect for an initiative that wasn't a fluke, that passes 3 different times. Isn't it just obvious that this is what the voters want? For them to turn around and say, well, if you're truly a representative of the people, start representing them. And not to lay it all on Gary Locke, there was an initiative that we did limiting the growth of property taxes. And that initiative 747 ended up passing in 2001. In 2007, the Supreme Court said the voters were misled into voting for that initiative, an initiative that lowered our car tabs. Chris Gregoire called a special session of the legislature and said it's clear what the voters wanted. They knew the destination. I'm going to implement this. Special session was done during committee days at the end of November of 2007 and implemented exactly what the voters ended up voting on. So we have a precedent of 2 Democrat governors willing to pass initiatives into law that they themselves weren't in agreement with, but both of them agreed, well, you can't say the voters didn't know what they were voting on. I mean, these were demonstrably understandable initiatives. They respected that. With Jay Inslee, there just seems to be a lack of listening, that if it's not in his world of agreement, it doesn't matter what the voters want, he will just do whatever he wants. And it's maddening to me, because the whole reason you have the initiative process is you shouldn't have to vote people out of office to get a policy you want. You know, maybe people like Inslee and think he's a great guy, but on this issue, he's tone deaf. You shouldn't have to vote him out to get a policy you agree with. And here you have something the voters have voted for 3 different times. It's exasperating to have the argument that the voters were confused by a measure that was so straightforward and so understandable. I think people are angry. They're frustrated. You can proactively do something. You can just refuse to renew your car tabs. That's what I'm doing. But in the meantime, until this happens, my car tabs are $0 until they're $30. But what can you do also, as Jim pointed out, you got to reach out to the governor. It is really up to him. It is not up to our elected officials to do this. Without Inslee, you're never going to get the car tabs, and you're going to get a special session, I should say. And he is going to be the governor from now until January, whether he wins the election or not. There's no reason why they can't have committee days in November and be able to implement this thing. At a minimum, get rid of this dishonest vehicle valuation system and tax vehicle, a $10,000 vehicle like it's worth $10,000. That alone, I think voters would feel a lot better about, but I don't think people are going to be satisfied until they write a check for $30 for their car tabs. And I'll keep fighting for it.
They never write a check for $30. It's at least $43.25.
I think voters would accept $43.25 to what they've got now.
Why not have it on the sign?
There's simply no reason why you have to get rid of every single tax and fee. You wanted to get rid of the largest ones. That's what we were trying to do with the initiative. No doubt if we got rid of the 75-cent fee, somebody'd complain about that. So we're trying to focus people's attention on the fact that we're trying to lower the cost of owning a vehicle in the state of Washington. Voters have clearly sent that message. The taxes and fees were explicitly laid out the initiative. It just defies common sense that the voters were confused by a measure that made that was so well covered by our fine media. As I suck up, no, I don't even know how to do that.
It's the other thing you need to keep in mind too is car tabs are a regressive tax. They hit the poorest people the hardest, and we hear so much in this state of complaint that our tax structure is regressive. This is one of the most regressive taxes. If you talk to working people who are struggling, they'll say that the high car tabs, a 3-digit or, God help us, 4-digit car tab renewal, that's a killer to a working person. And
Do you support like a progressive tax, like a capital gains tax then to replace that?
of course not. That's taking 3 turns around the block instead of 1. Let's just make the taxes we have flatter and fairer. Let's not add new taxes on, trying to correct iniquities in old taxes.
To answer Joe's question, though, it is interesting. The Seattle City Council has decided to get rid of the $60 fee, per vehicle fee. They're getting rid of it, and they're going to the voters and asking for a slightly higher sales tax in exchange for it. So, you know, here I am saying the Seattle City Council did something good. But here they are.
But they did.
They got rid of the
Acknowledge it.
$60 fee. And I thought that was a sign that maybe they were listening, that was a good positive thing or whatever. But I also thought, well, maybe they heard down the grapevine that the initiative was going to be upheld. I mean, I was optimistic, you know, that the court would stay consistent with its previous ruling on the single subject and everything. But this 9 Supreme Court justices basically said, nope, that's the rules back then. We got new rules now. So clearly you know, I do want to say this is an important point, is that I have dedicated my life to doing initiatives. I work really hard to do them right. I draft them as careful as I can, following the rules that they lay out for them. But you cannot make the observation that you can't escape the observation that why is it these initiatives are always the ones targeted with lawsuits and why they have so much trouble? Is that it's somehow I'm drafting them wrong, or is it possible the Supreme Court and the courts view differently initiatives that limit government's power versus expand it? There's simply no reason why a justice, as Judge Ferguson showed, you can be a liberal judge and still come to the conclusion that the voters weren't confused, that it was single subject. They chose to strike it down, not because it violated the single subject rule, but because it gave people more of their money back. It's a double standard. It's maddening to people. People see it, they recognize it, and using Eyman as a scapegoat isn't going to work when you've done it 3 different times and the second time it was upheld by the court. The reality is I'm following the rules that they lay out for me, but when they change the rules, all you can do is just do the best you can. And we've saved people tens of billions of dollars doing these initiatives, so they are paying off, but they make it hard. They make it hard. If I started doing liberal initiatives, I'd become a king and I'd be great and I'd be wonderful. But as long as I'm doing conservative initiatives, there is clearly always going to be a double standard.
At the proposition of King Eyman, Essex walks away.
I know. I would too. No, it's all good. Yeah. No, thank you for coming out. Appreciate it. Follow-up questions, always available.